Well, the parent company of the cruise ship that ran aground in Italy now bracing for a long and very costly road ahead. With rescue crews still searching the Costa Concordia, stock shares already taking a huge hit with a potential slew of lawsuits waiting in the wings. But this wouldn't be the company's first brush with the law. Miami defense attorney Michael Winkleman has some firsthand experience. You have sued this company Costa before. Where do these current and pending and imminent lawsuits take place in the United States? Because the parent company is incorporated here in the U.S., their corporate offices are in Florida, or does it get filed in Italy?
It's a good question, and just to be clear, Greg, I am a plaintiff's lawyer, not a defense lawyer, so I exclusively represent either cruise ship passengers or cruise ship workers that get hurt in suing the cruise lines. But to answer your question, strictly, my firm has had many cases against Costa Cruises, both in the United States and in Genoa, Italy. But if you look, the most important document in this kind of a tragedy is the cruise ticket contract, because when you go on a cruise, that's a binding contract. And here it says you have to sue in Genoa, Italy. So the first answer to your question is, even though they're incorporated here, courts in the U.S. routinely enforce these forum selection clauses that require the suit to be brought in Genoa, Italy.
Yeah. Now, look, if you file in Genoa, Italy, are there limitations on the amount that you can recover if you're injured or killed?
Sure. Unfortunately, as to both, there are. There's something called the Athens Convention that the cruise line puts in the ticket contract that basically says that if you get hurt, regardless of how badly you're hurt, it limits your damages to $75,000, which is roughly $75,000, which is an extremely limited amount. And in terms of deaths, if you were to file a lawsuit in the United States, then you would fall under the Death on the High Seas Act, which is a very harsh remedial statute which limits your damages to just the money that you provide to dependent beneficiaries, and the most common cruise ship passengers are elderly persons who are retired and don't have any dependent beneficiaries. Therefore, oftentimes under the Death in the High Seas Act, their cases are very significantly limited in value.
Yeah, and a lot of those victims and the victims' families would say this is a paltry sum for these valued lives. Is there any way to get around those limitations?
Absolutely. There are absolutely ways to get around the limitations, and that's what good lawyers will do, is to work to fight to get around them. With the Athens Convention, it's really, because it's just buried in the ticket contract, it's interesting to note that neither the U.S. nor Italy have ratified that, so it becomes an argument of whether or not it was reasonable to have this passenger, this U.S. passenger, be subject to this tiny little fine print buried in a contract, and the judge is ultimately the one who tests it for fundamental fairness. And I, of course, would argue there's nothing fundamentally fair about letting a multi-billion-dollar corporation off the hook to such a tune. And it's not just injury claims, it's also property claims, which I think is going to be one of the most abundant type of claims across the board.
Michael,
people that
wouldn't you argue that these are contracts of adhesion? There was no opportunity here for any of the ticket buyers to negotiate the terms.
Absolutely. It's absolutely a contract of adhesion, but there's United States Supreme Court precedent right on point saying that even these types of tickets are valid. But this is not just a cruise industry issue. This is anytime you buy anything online, every time a consumer clicks on something saying, I agree to the terms and conditions, nobody reads those. I'm a lawyer. I don't even read them. And corporations are allowed to really put in things that are just so ridiculous that I think it's only left to the courts to say, to draw the line of what's reasonable and what's unreasonable. But Greg, absolutely, I would argue it's unreasonable. 100% unreasonable.
What about another legal document, doctrine called res ipsa loquitur, which presumes negligence, so that the plaintiffs here don't even have to pursue the negligence? It's automatically assumed.
Sure. I think that's a good point. I'm not sure that res ipsa strictly applies, but here, I mean, even Costa is basically coming out and admitting that their captain was in fault. So in terms of liability, I think there are some issues that passengers face, but I do think that all the passengers that were wrong here have a strong right to recovery. This is a very clear case of negligence, even teetering on gross negligence against this cruise line. And I think that whether it's in the United States or whether it's in Genoa, the passengers will be able to make a recovery, both for personal injury as well as for property loss.
Right. Michael Winkleman, maritime lawyer, plaintiff's attorney, and thank you very much for being with us.
Thank you very much, Greg. Pleasure to be here.
Jenna?
There's certainly a lot more to that story.
Oh, yeah.
Coming
There's
up
going to be a lot of lawsuits.
weeks.
Everybody on board.
Wow. What did they do with the ship next? We have a lot of questions we're going to have to get answers for you on. In the meantime, here's another big story today.